We appreciate all of the guests who have appeared on our show and sincerely thank them for providing you, our audience, with useful information. However, the advice our guests provide is theirs, and we encourage you to seek out a professional if you have specific questions about any topic we cover on the Crushing Debt podcast. On this week's episode of the podcast, how to discharge student loans during COVID.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner with Yesner Law, and I've got a lot of content and a little bit of time to get to it. So I want to let you all know real quick that the sponsor for this week's episode, as it has been for a while, is Sam Cohen with Attorneys First Insurance. If you need E&O or errors and omissions or malpractice coverage and you're an attorney or a title company, contact Sam at attorneysfirst.com, or just go to his website, which is www.attorneysfirst.com. The other thing I wanted to remind you of is, again, if you are listening to this podcast either on YouTube or you're listening on some platform where you have not yet subscribed, go and check out SeanMYesner.com/subscribe. That'll get you the most popular episodes, the most downloaded episodes of the podcast, and it'll give you a place to subscribe if you haven't yet already. Subscribing is free, and I very, very much appreciate all of that. But I do want to get to this week's guest, who is a returning guest. Very happy to have her back, and I'll have to go back and double check, but I think this episode sets the record for most appearances on the show. So my guest has been on episode 50, episode 93, episode 99, and episode 106. So if you want to go check out any of those episodes, 50, 93, 99, and 106, and again, I'll try to link to all of this stuff here, but my peer, my friend, my fellow bankruptcy attorney. I won't go through the whole introduction. You can go listen to those other episodes if you want her full introduction. But welcome back for the fifth time, Christie Arkovich. Welcome.
Thank you, Sean. We just can't shut up about student loans, it seems.
Exactly. Well, it's a big topic right now, especially. So just to get into it sort of as background, we're recording here the end of August, beginning of September. I think this episode will come out in September sometime. But I know that the CARES Act did impact student loan repayments. So in other words, COVID has had an impact on student loan repayments. Isn't there an issue right now that expires pretty soon here, but where student loan payments were frozen or you didn't have to make student loan payments under the CARES Act, right?
Yes. Back in March, the CARES Act allowed for forbearance of direct federal loans as well as interest waiver. And most of the older FFEL loans have the forbearance too, but they'll still accrue interest. But interestingly, you probably haven't heard, last weekend, President Trump signed an executive order that moved the September 30 deadline for the loans to restart payment to December 31. So a lot of folks are out there taking advantage of this time. They're making payments anyway, having it go directly to principal. That's a great way to reduce debt. But we wanted to talk about a couple of things today that are a little unique, a little outside the box, and they can really amount to a huge amount of forgiveness and debt waivers during this period of COVID that no one's really talking about. So I wanted to help try to get the word out for that.
Yeah, and I do want to get to that. While I got you on the episode, however, I did have one more CARES Act sort of question, and then we'll get to the other topics too. But so I've had people ask me, while interest is forgiven, while payments are suspended right now, while we don't have to make payments, should I? And my answer was always, well, if it's an amortizing performing student loan, if you're making a federal student loan, if you're making payments, you're directly reducing principal. But my understanding, if you're on an income-driven repayment plan, if you're on an IDR, it may not make sense. In other words, you're not going to pay down principal. Am I right? Am I in the ballpark?
No, you're absolutely correct. For income-driven, there would really be no point in making those extra payments now. I would instead try to add that money to a safety net, just keep it in a safe account or something like that, savings account. It's different though for private loans. Those don't have any kind of interest waiver. So paying those down would be good right now. And if you expect to not have forgiveness after either 10 years with public service or 20 or 25 with any of the regular plans, then by all means, use this time to pay down that debt, but not if you expect forgiveness. That would really just be throwing more money away.
Okay, got it. So glad to see him giving people the right advice here. So
yep, you are. You're spot on.
Good. So I wanted to discuss, and I know you wanted to come on to discuss, especially now during COVID, some people may have the opportunity to really impact above and beyond what CARES Act provides that we just talked about. Some people may really be able to impact positively for them. Mm-hmm. Their student loan debt, their student loan forgiveness. Maybe they're out of work. Maybe they're getting ready to go back to work. Maybe they're looking at retirement. And so I know the two things that we wanted to talk about specifically. One was total permanent disability forgiveness. So why don't you take a minute and talk about, number one, what that is, but then also how that's impacted here in terms of student loans and COVID and everything that's going on right now.
The education department has a program called Total and Permanent Disability, and it's very different than Social Security disability. There's no hearings. It doesn't go through a long period of denial and appeals and all that. So it's something that we can get rid of and have 100% forgiveness tax-free of federal student loans within less than 3 months. It's awesome. And it's really one area, maybe the only area that Secretary DeVos hasn't monkeyed with to try to prevent forgiveness, like the borrower defense to repayment for fraudulent schools. That's not going so well. But with this disability, it's going fantastic. We have not had one turned down, and that is an impressive record. We've able to obtain 100% forgiveness 100% of the time. And we even had one this spring that was over $1 million that was forgiveness. This was a neurologist's father, and he had paid to put 3 sons through Parent Plus loans. And he'd paid a boatload of money over the years, but with forbearance and capitalization and the way it worked, even though he probably had paid much of the principal over the 20-some years of payments, he still owed $1 million. And so we got rid of all of that in less than 3 months. And so during COVID, we have a lot of folks who are worried about returning to work. I mean, to be frank, they're at home, they're safe, and they recognize that retirement's right around the corner for them. Maybe they were going to retire in 6 months, maybe a year or two. And this is an opportunity that if you do want to take a bit of a gap, maybe not returning to work is a viable solution, especially if you owe a ton of money to the Department of Ed, because you can utilize this time to get rid of that. We file total and permanent disability apps. And the one catch that someone should be aware of is that there is a 3-year monitoring period. So that means once it's approved, for 3 years, that person can't make more than the poverty level for their family size in terms of employment income. So they can get disability income, Social Security, investment income. Their spouse can make whatever. They can have a little part-time job, for spending money, grocery money, just to keep active, something like that. But they can't make over, in Florida, a family of 2, it's $17,000 and change. So they can't make over that. But if someone's willing to commit to that requirement for 3 years and not return to work right now, if they have the factors, and we can go through that qualify someone for a TPD discharge, what a fantastic time to be done with their federal loans once and for all. And it's tax-free right now.
Yeah, and that's what I wanted to mention, tax-free forgiveness. So normally when a lender waives any kind of a debt, then the borrower would get a 1099, forgiveness of debt income. So they'd have to pay income tax on that forgiven debt. The way I've always explained it is, if you're contractually obligated to pay something back and then you don't, well, then you got a benefit. And anytime you get a benefit, Uncle Sam holds out his hand because he wants his cut. But there's under this total permanent disability forgiveness, there's no 1099 forgiveness of debt tax consequences. Am I understanding?
Exactly. The law is funded through 2025. So as long as we get our work done and we have that 3-year monitoring fall within that time period before 2025, there will never be a 1099. And that's important. During our practice, we have always wanted to not exchange a student loan debt for an IRS debt. What are we really doing if we're doing that? So we pay a lot of attention to making sure that our clients don't incur debt by, forgiveness and so forth. And we do the same for when we try to do settlements and discharges, same kind of concept. We build in the language in the agreement so that there's an argument to be made with the IRS that it's disputed, it's not actually forgiven, it's discharged, it's not actually forgiven, anything that avoids a tax debt. So this total and permanent disability is perfect for that because it's 100% tax-free.
That's very cool. So you mentioned a bit ago the different factors for total permanent disability. So do you know what those are?
Yeah. The way they look at it is total and permanent disability basically means that someone can't engage in substantial gainful activity, which is significant and productive physical or mental work activities. I actually had to read that because I don't have that memorized. I have a simpler version. Okay, that's the real definition. The simpler version is you just don't go back to work. You just can't go back to work doing what you used to do full time. How hard is that? You can't go back to work doing the type of stuff you're used to. Maybe it's what you were trained for. Maybe it's where you were educated. And you just can't do that full time any longer. And there are a lot of folks who we use a combination of things, medical underlying conditions. We use maybe side effects from medication, maybe someone's advanced age. A lot of it deals with chronic conditions and cognitive type stuff. Our best clients that we believe that are most apt for this kind of relief are those that have memory issues. They're not sure what tomorrow is going to look like. An employer needs someone there every single day or working at home, however we're doing it. Inconsistency is not something they can deal with. An employer can fairly well reasonably accommodate someone who needs to sit, every 10 minutes, every 2 hours. They need to have something that helps them lift. They can't lift more than 10 pounds, something like that. Those are fairly easy things to accommodate. But how do you accommodate someone who cognitively, has some issues there, or emotionally, or working with others? And so those are the types of things that we're working on. And we also have a physician that has a specialty of occupational medicine that is on board for examinations when necessary. We encourage our clients to use their own doctors whenever possible, just because they have good and long-term involvement with that patient, knowing what they're having to go through and so forth. So I hope that answers your question on what we're looking for.
Yeah. No, I think that does. Yeah, thank you. So the other thing that we were talking about too is in terms of maybe filing bankruptcy now for somebody because of COVID or because of the impact on their revenue based on COVID. So what do you mean when we talk about, filing bankruptcy now because of COVID or because of the impact on revenue?
Sure. A perfect example is exactly what we saw during the foreclosure crisis. We would have someone that would lose their job, and they always felt, well, once I get my job back, I'll be able to catch up on all this debt I'm accruing. They're running up credit card debts, putting medical bills and house payments and living expenses on there. Then they got a job, come 2010, 2011, 2012, $80,000 a year job. Now, all of a sudden, if they were to look at filing bankruptcy, they would have to be in potentially a 5-year Chapter 13 and have to pay a disposable monthly income to the trustee. Had they been aware of their ability to file right before they got that good job, whether it was midway or towards the end of their unemployment period, they would have had a Chapter 7 entitlement, as you know, and they would have had a discharge in about 3 months. So our argument with COVID right now is a lot of folks are either unemployed, maybe they are under the special federal unemployment provision, maybe not. That's been cut, I know, recently. Or their pay's been cut. Maybe they're making 80% instead of 100%. Now they qualify for Chapter 7 where previously they didn't. So why not take this opportunity and look at it as a silver lining? You have the opportunity to file bankruptcy now that usually doesn't exist when you're normally 100% employed. And so we can use that as a platform then to try to discharge private student loans. Normally, private student loans have a high interest rate, 8%, 10, 15%. We see it all across the board. I have a client that we spoke with today. When she graduated with her master's in social work, it wasn't all that much. I don't remember how much it was. She didn't remember herself, but now it's $180,000. She owes at age 52, $180,000 of private student loan. This was just this morning. She has federal loans too, but the federal loans have programs, and so they can work with her. The private don't. The private say, pay me $1,500 this month, or we're going to sue, or we're going to do whatever, and they're calling everyone and so forth. So if someone's unemployed right now, she was employed, so we can't do this for her, but if someone's unemployed right now or they're making less money, file a Chapter 7. let us do the adversary. Let us get rid of those private student loans while this opportunity exists. When you're making 100% pay in a few more months, that opportunity is gone forever. And it's an excellent opportunity to get rid of private student loan debt that otherwise there's just nothing out there for them.
Yeah, and so I think there's two prongs there. If I'm hearing you right, if I'm understanding you right. So the first prong is that my income has gone down, and the way I've described it to clients is Chapter 7 is a snapshot in time. So
Yes.
If my income has gone down, I take that snapshot. My income qualifies me for Chapter 7. But then the second part of that analysis is because of my employment status due to COVID, now I have a better opportunity at filing that adversary proceeding, that lawsuit within the bankruptcy to discharge the private student loans.
Yes, and it's really because of some, fairly new case law with respect to what is a dischargeable private student loan. And so there's a variety of arguments. Maybe someone went to an institution that wasn't eligible for federal funding. Believe it or not, there's a lot of schools out there that are accredited, but they can't get federal funds. And when they're not on a certain list, then these private loans are dischargeable. Maybe that institution was open for less than 2 years. There's a few arguments. One of the biggest arguments that we like a lot is called cost of attendance. And so for the client this morning, for instance, she borrowed for her master's degree for social work as much as she could from the federal government. It wasn't quite enough. And so she also had a number of private student loans. Much of that private student loan debt was actually used for things other than the cost of education, and they were beyond what she really needed for her living expenses. But these private lenders, they figure, why not loan the money? It's non-dischargeable, or at least we're going to say it's non-dischargeable. And we're going to get 8 to 15% interest on this money, and everybody's going to think it's non-dischargeable. Well, in reality, it is dischargeable because it's beyond the cost of education. And it's a technical argument, but if you read the IRS code and the bankruptcy code together, when a loan is mixed or beyond the cost of education, it is dischargeable. And we've been regularly filing these cases in Tampa and Orlando. And we usually are ending up with stipulations of discharge and or a very, very nice settlement agreement that we're pleased, to get for our clients. We've been teaching others around the nation. About once every week or two, I've got some attorney from some state that's on a conference call with me where we're going through an hour, class basically on here's how we're doing it, here's what we're doing, and so forth. And it's something that's really working right now. So it's just a good opportunity for someone to think about clearing the deck of a private student loan before they can return to work, because once they're back to work, they can't file in Chapter 7 any longer, and therefore I don't have the platform to do my magic on this private student loan.
Right. So let me give out your contact information, which I didn't do at the beginning. So if you are interested in talking to Christie, if you want to talk to her about your student loans, or if you're an attorney that wants to talk to her about how can I help my clients discharge their student loans, it's ChristieArkovich.com. So CHRISTIE. Arkovich is ARKOVICH.com. Or you can email her at Christie@ChristieArkovich.com. And again, for those of you that missed it, I'll put it in the description of the podcast episode. And so I'll link to her email and her website from there. One quick question that I had, do you know of anything bouncing around in Congress? I mean, now that we're getting close to the election, I don't know how busy Congress is going to be necessarily, and I don't know how busy they are normally necessarily, but do you know of anything bouncing around in the House or the Senate about student loans?
Well, there's always a bunch of stuff, as you know, amending the bankruptcy code. That's never really gotten anywhere with student loans, but that's up there. Different things about public service problems that we're having, where Congress previously basically passed the law that said that someone's entitled to public service loan forgiveness, but only if they have a direct loan owned by the government, not the other federally backed loans that are only guaranteed by the government. So that disconnect where people don't know what they have, and they're being told they qualify and they really don't, or they don't understand. There's always a bill or two about that. And recently, the HEROES Act that's under consideration now by Congress, which I understand before President Trump signed those executive orders, there were the House, I think, wanted $4 trillion or $3 trillion, and the Republicans wanted $1 trillion. So they're kind of, long ways apart on that. But there was a provision that was being discussed where it would basically fix that problem, where public service loan forgiveness would apply to any federally backed loan, whether it was an older FFEL loan that's been discontinued now, or whether it's a newer direct. And that would be huge, especially if it was retroactive, because that law was designed to help those and encourage people to go into the public services professions. And they wouldn't have done it, maybe, had it not been for that promise. And we're breaking that promise by not allowing for those with federally backed loans to be qualified, because it's the same as a direct loan. It just happened to be originated by a private lender. Other than that, it's the same as a federal direct loan. It's guaranteed by the government. It has the same programs that apply. It really should. So there's that out there. There's always talk about some kind of forgiveness, 10,000, 30,000, all of it, who knows what. My position has always been, I wouldn't be a lawyer today if it wasn't for the student loan program. So I believe in the program. I do think that it's broken and could be fixed in a few of the more technical ways. One is public service, like we talked about. Another is the interest rate. The federal loan interest rate averages 6.8. For grad loans, it's 8 or 8.25 or 8.5. That's high. I can get a mortgage, you can get a mortgage out there for 2 something, maybe 3 on a bad day. And so why not reduce the overall student loan debt to 2 or 3%? Most people who go to school, they would like to repay, but they can't afford to repay under the conditions that have been imposed upon them, which is capitalizing interest and 25% collection costs upon a default. If you have a student loan of $100,000, you now have $25,000 more because you didn't make a payment for 9 months and you didn't know what to do and you accidentally defaulted. We see that, and we see people default more than once. That's 50%, if you had 2 defaults. So that's what they can't pay. And also, if you happen to go to school in 06, 07, 08, and you weren't able to get a job for a few months or a few years, that forbearance and that capitalization of interest, you might have owed 30 when you graduated. Now you owe 60 or 70. What may have originally been repayable, not so much anymore. And so if we could drop the interest rate across the board to 3%, that might be nice. If we could have an overall fix that discouraged forbearance, especially during bankruptcy. Your listeners and you, Sean, I don't know if you knew this, but when you file a bankruptcy, normally a federal student loan is just put in forbearance. Nobody talks. There's an automatic stay that prevents discussions, actually, and that's the end. And so when you come out of a 5-year case, you might have owed $100,000 on a federal student loan. Now you owe nearly $150,000. So the Middle District took it upon itself to pass an administrative order. And the Middle District is the 3rd largest bankruptcy district in the country. So this is a big court making this decision. And other courts around the nation were in different processes to try to adopt something similar when COVID hit. So, they'll have to pick that back up when this is over. But essentially, that program is designed to let people participate in public service and income-driven plans while they're in bankruptcy. Why shouldn't they be allowed to accrue time towards forgiveness like everybody else is? So if we could fix that instead of just our district fixing it. And, by the way, our program, the Department of Ed and Department of Justice, they don't like it so well, but so far they're adapting to it, I guess I should say. But it might be nice if that was done on a nationwide basis. So there's always things going on and so forth.
Yeah. And I've always explained to clients that the student loans are not discharged, but it's always been my understanding too that they are paid outside of if you're on a public service loan forgiveness or an income-driven repayment, something here in Tampa that we talked about. But otherwise, they get the same payout as the unsecured creditors. They're just not discharged. So
correct.
If you're paying your unsecured creditors 20% through your Chapter 13 plan, your student loans are going to get 20% of what they're owed. But then when the bankruptcy's over, you're going to owe them the other 80% plus interest.
Right.
So, right. Yeah, I mean, I'm sort of in the same boat as you. If not for student loans, I wouldn't have been able to finish and graduate law school. I was lucky enough that undergrad was taken care of, but law school, I had to borrow to fund. And I agree with you. There's some people that say, well, if you can't afford to borrow it, you shouldn't get the education, but that's not really the issue. It's even after I graduated law school, I graduated law school 20 something years ago now. And I remember my first job out of law school, I was making like 20 or 24 a year, some obscenely low number. But I remember it wasn't enough to repay the student loans. So I deferred them for a few years until I made some more money, and that, exploded them up a little bit. So I agree with you that the issue is not necessarily borrowing to pay for the education. I think the issue is all the stuff that happens after you graduate and then the loans become due. I think that's where a ton of people trip up.
Right. And we basically have two tracks. We have the track where someone doesn't know how the system works and they end up having to pay 3, 4, 5, 6 times more than what they graduated with. So they end up basically subsidizing the system. And then we have the second track where people can't afford to make a payment or hardly anything towards their loans. And so they're on a full forgiveness track, but it's for up to 25 years. And so it's a large part of their career. Gone is the track, or at least I don't see very many people that are in the 10-year standard repayment. I mean, when I graduated in 1992 or 91 from law school, that's what it was, a 10-year standard. And fortunately, I had a 1-to-1 ratio. So my first job paid, I think, $40,000. My loans were $45,000. So it was roughly equivalent, and it wasn't difficult for me to repay. We don't see that kind of thing anymore. I mean, nobody's on a 10-year standard. Everybody's on extended ones. The rates of interest, in the 80s and 90s, interest was actually higher. It was in the teens, where now the federal rate is 6.8. But what I'm saying is today, even that's high, compared to a mortgage. And I think 3 would, it would allow the government to recoup some time for that money, or money for that time, I'm sorry, but not be so overwhelming that someone is just never able to pay it down.
I consider myself lucky. I think my student loans will be paid off when I'm 55. I consider myself lucky, which I think probably tells you everything you need to know about the student debt repayment system, that I'll be lucky to pay them off when I'm 55.
Right. Well, I have a lot of people, when I tell them the 25 years and we do the math, they're going to be in their 70s and 80s. It's kind of ridiculous. But there's ways around that. And so whenever anyone comes to me and they say, well, I'm afraid that I can't retire because I need to pay my student loans, that's not true. There's usually always a fix. It may not be what they expect it to be, and they certainly shouldn't expect their servicer to go wave a flag and tell them of that. The servicer represents the creditors. And so they may give someone all of their options, none of their options, or something in between. And it's important that a borrower have their own advocate, or that they educate themselves on all the different programs and all the different ins and outs, because you can't rely on the servicer for your sole source of information. They represent the other side. They're nothing more than a debt collector.
Yeah, no, I understand. Well, before we wrap up, anything we didn't talk about, anything that you want to add?
No, that's about it. I would like to talk with you later about getting our estate planning attorney on your show, because she's doing some great things. And I think it'd be good for your listeners. But that's just what I wanted to bring everyone's attention to now, is think beyond just saving interest and making a payment to pay down principal. You can do so much more during this COVID time to eliminate both federal and private debt. Take the shot. It's not going to be around forever. COVID will be over next year, hopefully this time next year. And take that shot, clear the debt, and get rid of it now while you can.
Yeah, no, I appreciate that. And absolutely, the invitation is open for you to come back for episode number 6. For you to have anyone from your firm come back for episode,
Thank you, Sean.
for their episode number 1. No, you always give great information, especially about student loans and about all the other stuff. So yeah, I really appreciate you coming on the show. And yeah, so I think that will do it for this week's episode of the Crushing Debt Podcast. Thank you again to Christie, ChristieArkovich.com, or Christie at ChristieArkovich.com. Again, I'll put all that stuff on the episode notes so you can contact her. If you want to hear some of her previous episodes, episode 50, 93, 99, and 106. But I think
sounds like bingo.
Yeah, I know. Lottery numbers or something. Maybe you should go out and play those lottery numbers. So that'll do it for this week's episode. Like I say at the end of every episode, I hope that at the end of the month you have more money, and not at the end of the money you have more month. That'll do it for this week's episode, and we look forward to talking to you in next week's episode of the podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.